right, welcome to Politics Today, reaching you live from our global headquarters here in the nation's commercial nerve center, Lagos. I'm Jeffrey Uzama. And of course, tracking the polity, as I've always said, is our daily responsibility to help you condense what's been happening across board. But a lot happened in the court today, which is going to be a core part of our conversation on the program as far as the Rivers House of Assembly is concerned, as well as the latest development in Edo politics concerning the PDP and all of the primaries that occurred there, as well as the judgment of the Court of Appeal concerning the members of the House of Assembly, the controversy around Martins Amaewhule and others, as well as Victor Okojombo. So that's going to be one of the major conversations we'll be having today on the program. A senior advocate of Nigeria will break it down for us, as well as the parties involved in all of this, representing as much as possible. We'll talk about that. But first, let's tell you that the President, Bola Tinubu, has inaugurated the Presidential Economic Coordinating Council. The council will be tasked with finding feasible solution to the economic challenges facing the nation. Among members of the council are government officials, top players in the private sector, including the president of the Dangote Industries Limited, Mr. Aliko Dangote, chairman of the United Bank for Africa, that's UBA, Mr. Tony Elumelu, Chief Executive Officer of Financial Derivatives Company Limited, among others. Briefing State House correspondent after the inauguration of the council. Minister of Finance and Coordinating Minister of the Economy, Mr. Wale Edun, said the council is to meet and report to the President monthly. Mr. Edu also said part of the federal government plan involves a 2 trillion naira package aimed at stabilizing the economy, and it includes 350 billion naira for health and social welfare, 500 billion naira for agriculture and food security, 500 billion naira for energy and power sector, and 650 billion naira for general business support. All right. Guns in the private sector, as well as top government officials. So 2 trillion naira to be injected into the polity or into the economy, targeted at all of these sectors we've mentioned. And let's see how that helps to revitalize and reposition our economic fortune. But leaving all of that happened at the Villa, let's head to the court, where Justice Inyako of the Federal High Court, Abuja, has declared as invalid the People's Democratic Party's primary election that produced Asue Godalo as its governorship candidate in Edo State. The primary election conducted in February 2022, on February 2024, was voided on the ground that 378 delegates who were supposed to vote at that primary election were unlawfully excluded by the PDP. Justice Inyako nullified the primary election while delivering judgment in a suit instituted by the aggrieved delegates. The suit was instituted by Honorable Kelvin Mohammed in a representative capacity. Justice Ekwo also held that both the provisions of the Electoral Act 2022 and the PDP guidelines were violated in the conduct of the primary election at the Samuel Ogbemudia Stadium in Benin City, the state capital. The plaintiff, Mr. Kelvin Mohammed, Mr. Gabriel Okodua, and Mr. Ederaho Osage, on behalf of others in 12 local government areas and 127 wards, had averred that it will be in the interest of justice for their reliefs to be granted. The 378 delegates are believed to be those loyal to Philip Shaibu, the impeached deputy governor of Edo State. Well, we're not done with the courts. A court of appeal sitting in Abuja has overturned the order of the State High Court, which barred Martins Amaewhule and 24 others lawmakers from the River State House of Assembly from parading themselves as Speaker and members of the Assembly, respectively. The court stated that Section 273, subsection 3 of the Constitution grants the Federal High Court the authority to decide whether or not an Assembly member seat has become vacant. It was further affirmed that the Federal High Court holds exclusive jurisdiction in matters regarding the vacancy of Assembly seats. The appellate court emphasized that the explicit mention of the Federal High Court in Section 273 of the Constitution inherently excludes the State High Courts from such jurisdiction. Therefore, the appellate court declared that the ex parte order issued by the River State High Court was made without proper jurisdiction and is consequently null and void. In May this year, excuse me, Justice Charles Wale had, while ruling on a motion ex parte following a prayer brought before his court by Mr. Victor Okojombo, issued an ex parte order barring Martin Amaewhule and 24 others from parading themselves as members of the State House of Assembly, which Amewule challenged at the appellate court. Meanwhile, Mr. Martins Amewule has reacted to the latest judgment. Oh, well, we hope we can get his reaction as much as possible because we understand he was in the nation's capital. It's been quite a ride for the Rivers State House of Assembly. And you know the stories if you've been following the program as much as possible. But we have a lot to talk about as far as legalese and the politics is concerned on the program. But let's bring you our political round of stories.
The president of the Nigerian Bar Association, Mr. Yakubu Maikyau, is calling on the National Assembly to make laws that grant recognition to traditional institutions. According to him, the traditional institutions have, over the years, shown commitment to national development. He said this during a panel discussion of the House representatives with traditional rulers.
Some of these laws upon which these institutions are predicated today are archaic. They do not allow the traditional institutions to perform in the way that they can bring this value that all of us agree they have to bring to bear in dealing with our national issues.
The presidential candidate of the Labour Party in the 2023 general election, Mr. Peter Obi, has met with the Transition Committee of the Nigeria Labour Congress with the aim of resolving the leadership crisis between the Labour Party and the NLC. Addressing journalists after the meeting, which was held behind closed doors, Mr. Peter Obi says he will continue to engage both groups to ensure that all grievances are resolved amicably.
I did mention that the group which within our family is known as Transition Committee, I'm going to meet them. And that is why I'm here.
The governor of Kaduna State, Senator Obasani, is assuring traditional rulers that his administration will continue to carry them along in the implementation of government policies and addressing the security and developmental challenges confronting the state. The governor stated this while meeting with the monarchs at the government house in Kaduna, where he also ordered the immediate reinstatement of the rulers who were deposed by the immediate past governor, Nasir El-Rufai. He also affirms that his decision to reinstate them is in line with his administration's commitment to abide by the rule of law.
Leadership remains the cornerstone for effectively addressing all of the challenges confronting Nigeria today. That necessarily include your leadership because you are the closest to the people.
Ahead of the local government elections scheduled for August 31st in Kebbi State, the All Progressives Congress in the state has held a meeting with key stakeholders to strengthen unity within the party. The meeting, presided over by Governor Nasir Idris, was attended by prominent party members, including the immediate past governor of the state and current Minister for Budget and Economic Planning, Abubakar Bagudu, former Governor Saidu Dakingari, former Minister for Justice and Attorney General of the Federation, Abubakar Malami, Minister of State for Education, Dr. Tanko Yusuf Sununu, amongst others.
The election of local government will be conducted free and fair. And also, I want to tell you that APC is a formidable party. And by God's grace, if the record will pay, inshallah, it will pay us as APC.
Governor Chukwuma Soludo has sworn in the newly appointed Transition Committee chairman for the 21 local government areas of Anambra State. Addressing the chairman at the government house in Oka, the governor reminds them of the task before them and charges them to serve the people selflessly in order to strengthen democracy at the grassroots.
Welcome back. And of course, it's time to talk about the issues of the day. And it has to do with a lot of legalese, as I said. Two judgments today, one from the Court of Appeal sits in Abuja, where the judge held that the decision by the State High Court, Justice Charles Wale, that ruled against Mr. Martins Amewule in a suit brought against him by Victor Kojombo, the two gentlemen who are battling over who is the authentic Speaker of the State House of Assembly. The judge ruled in favor of Amewule in that particular case, based on the fact that it's more like a judicial overreach. That's what we'll talk about today, as well as the issue in Edo State, where the court has also said that the primary election of the PDP, indirect primary held by the PDP, has been nullified because certain persons who are delegates were not included in that exercise, and they are believed to be loyal to the former or the impeached Deputy Governor of Edo State, Mr. Philip Shaibu. That's why we're being joined in the program by Senior Advocate of Nigeria, Mr. Wahab Shutu. Mr. Shutu, thank you so much for coming on the program.
Thank you for inviting me.
So, Senior Advocate, let's start from 1 to 2. Let's start from the Rivers case, which is the latest before we get to the Edo State case. I wonder what you make of that particular situation, because we've all been waiting for this particular judgment because the court has reserved judgment. In that case that was decided, though it was an ex parte granted, restraining the Amewule group from parading themselves as both Speaker and members of the House, and now they appeal, and now the court has said the lower court was wrong. I want to, maybe your first impression about that particular case.
Well, it's a judicial issue. Yeah, the court of appeal took that position after a careful interpretation of the relevant provisions of the law, including constitutional provisions, as to the court that has jurisdiction to make such a pronouncement. And the court came to the conclusion that in this case, it is the Federal High Court that is entitled to make such a pronouncement, and that the High Court lacks jurisdiction to entertain the matter in the first instance. So orders made by the High Court were judged incompetent. So the status quo ante bellum resumes. So until that, the Court of Appeal has sustained as a rule that, as far as that subject matter is concerned, it is the Federal High Court that has jurisdiction, that the State High Court does not have jurisdiction to entertain the matter. I think let's leave it at that.
So are you saying, by implication, that this was more of what I'll call a judicial reprimand for jurisdictional overreach?
Yes, that's what it is. The Court of Appeal has clearly ruled that the lower court that entertained the matter lacks jurisdiction. And when the court lacks jurisdiction to entertain a matter, whatever orders it makes is a judge incompetent. And that's what the situation is as far as that case is concerned.
So what will now be status quo, whether it's antebellum or status quo? Because the substantive issue was that they approached the State High Court, which doesn't have jurisdiction, by this decision of the court to say, this gentleman defected, so they do not qualify to be members of the House. Their seats are vacant, and an ex parte was granted. So now that it is like this, who do we say is the Speaker of the, by law? Because you're the lawyer here, so you help us make sense. I don't like to make assumptions.
Well, by law, the party, the status quo before those who went to court, before the lower court went to court, is the status quo to be recognized. So what the Court of Appeal has said is that the holding of the trial court was erroneous. So the status quo remains what was operating before they went to court.
Leonard, I'm going to bother you a bit on this because I have the prayers of that particular case in my hand.
Okay.
Although I haven't seen the C, I don't know whether the CTC is ready, but we haven't gotten the CTC or the reasoning of their Lord Justice.
It is more useful,
yes,
to comment on
the reasoning
on judgment of court after citing the certified true copy of the judgment.
Yes.
And after going through the judgment and also going through the record of proceedings, including the processes, that will make you to be able to make informed commentary.
Okay.
Yes.
Just for the sake of just making comment on this particular issue, given the fact that the court has now said you do not have jurisdiction,
yes,
you didn't have any reason to even entertain this case.
Yes.
I want to read to you some of the prayers that Amewule sought and what this now means based on those prayers.
Okay.
an order restraining Okojombo from parading himself as speaker and others as well, an order, which is the 10th prayer, an order setting aside purported meetings, sittings, proceedings, or deliberations of the assembly presided over by Okojombo with only 2 members in attendance. The 11th one is interesting. An order setting aside all actions, steps, decisions, and or resolutions of the purported assembly presided over by Okojombo. Okojombo has presided over swearing-in of screening of commissioners and screening of caretaker committee. Does this judgment nullify all of that?
Well, if the court that entertained the matter, the lower court, is then said to lack jurisdiction, it means that we return to the status quo ante bellum. It means that all these prayers purportedly setting aside all these actions remain null and void for now until you approach the appropriate court. The court has not made any pronouncement on these reliefs because the Court of Appeal is saying the court that adjudicated on these reliefs lack jurisdiction to entertain. They should have been in another forum, not that court.
Okay. Just for the purpose of our audience, if my producer can put up the 10th and 11th prayers, I want the audience to be part of the conversation so that as I engage, if we can get that 10th and 11th prayers of Amewule, where he sought relief of that particular cause. So that's it. I just wanted the audience to see what I'm talking about, not just reading. So I wanted to find out from you. So let's go to the 11th one, if we can, so that your intervention, which I sought to be able to be sure, because whether everything they've done is nullified. But when we see the CTC, we'll be able to make sense. But before we move on to the issue of Edo State, one more question, Leonard Silk. A judge, what will give a judge the right to preside over issues that he has no jurisdiction over? Because the Constitution is very clear in Section 272, I think so, or subsection 3, that it is only the Federal High Court that has the power to make the pronouncement. Although they did not make pronouncement on some substantive issue, they granted an ex parte. So is there a condition that the State High Court can grant an ex parte for an issue that the Federal High Court is supposed to preside over?
When a court lacks jurisdiction to entertain a matter, that the implication is that that court also lacks jurisdiction to make any order, whether it's party, interlocutory, or final. What it means when they say a court lacks jurisdiction is that it lacks the powers to entertain the matter. It is bereft of any judicial powers to entertain that subject matter. You know, jurisdiction of a court is defined by the subject matter of the action. And the subject matter of that every court is entitled to adjudicate upon is spelled out. Some courts have, concurrent jurisdiction. There are matters that you can litigate at the level of the Federal High Court and the High Court concurrently. We are talking of fundamental rights enforcement actions. Either of those courts can answer. There are matters wherein a court has only a particular court has original jurisdiction. You are talking of disputes between states and federal government, and disputes between states and states. You know, the Supreme Court has original jurisdiction. That's the only court that can entertain it. That's where you can commence the action. Okay. Now, there are also situations where certain courts are vested with exclusive jurisdiction. Labor-related matters is vested only in National Industrial Court. Yeah. And there are some other matters exclusively reserved for the Federal High Court to entertain. I'm talking of matters enumerated under Section 251 of the Constitution. Only the Federal High Court retain the exclusive jurisdiction to entertain those matters. So when you go and commence those matters in the High Court, you are just wasting your time. You are wasting valuable judicial time. The action is incompetent. And when an action is incompetent, it means that the court lack jurisdiction to entertain the matter. Let us say I ask that question deliberately because something is playing out also in Kano State, where it's an issue of whether this has jurisdiction or the other. So why would judges entertain cases they don't have jurisdiction over? That's actually my question. Well, that is, with due respect, That's a gross example. I mean, an example of judicial rascality. You have no business delving into matters in respect of which you have no jurisdiction. Because the implication is that as a judge, you should know. Judges are the repository of legal knowledge. They are the custodians of our laws. They swear to an oath to observe the tenets of our laws. They are not supposed to act in excess of jurisdiction or outside their judicial powers. And most judges know this. Are presumed to know. So when a judge deliberately sidelines the Constitution, constitutional provisions, and statutory provisions, and has to assume jurisdiction over a matter in which clearly he has no jurisdiction,
Sorry.
My view is that that's an exercise of judicial rascality.
So in your
but there are remedies for that.
Okay.
That is why we have appellate courts.
Okay.
To be able to say, okay, what you have done is wrong.
Lenese,
yes.
We'll jump to the issue of Edo State, but yet again, maybe for emphasis, who is the Speaker of the House now?
The Speaker of the House of
Rivers State House of Assembly. Am I putting you on the spot here?
You are putting me on the spot because the names of particular individuals.
Ame Wule is the one that got this judgment
yes.
of the Court of Appeal in his favor.
His favor.
Oko Jumbo is the one that got the judgment at the lower court that has now been overturned.
Yes.
So who is the Speaker?
Well,
in the eyes of the law.
The one that has been overturned is not the Speaker.
Okay.
It's not the Speaker. You see, when a pronouncement is made by a court, rightly or wrongly, it still remains the law. You were mentioning the fact that when a court exercises a jurisdiction in a matter in which it does not have jurisdiction, it doesn't mean that exercise of jurisdiction is void automatically. It has to be set aside by a superior court, because a court has jurisdiction to be right as well as jurisdiction to be wrong. So if, as a judge, you exercise jurisdiction over a subject matter and make pronouncements in respect of a matter in which ordinarily you don't have jurisdiction,
okay,
that pronouncement is not void. It still remains valid until it is set aside by a superior court.
Okay.
So even though it is wrong, you can only
set aside.
First.
Okay, first. No matter how illegal it is. Okay, let's now move to Edo State. I want your quick, maybe your first impression of this outcome. They conducted a primary. It was a very contentious issue. Even before the primary, there were 10 of them, I think so, and eventually Mr. Aso Ighodalo emerged. But we had a parallel Congress somewhere in another location outside Samuel Ogbemudia Stadium. But now the court has said, for excluding a particular number of people, about 300 and something.
78.
78. Whatever you did at Samuel Ogbemudia is nullified. Your take?
You see, in making a comment, I have to preface my comments on this matter by saying that I'm yet to read the full text of the judgment. I don't know the processes filed in the case. And I've not also cited the record of proceedings. But looking at the law, what the court has said is that there's a case of wrongful exclusion of 378 delegates here. And because these 378 delegates were excluded, the entire primary is void. And that there's no primary. That's what the judge has ruled. Yeah. Now, the question you want to ask yourself is this. When was this suit filed? Was it filed after the primary? Or was it filed before the primary? What I found out, in my random checks revealed that the suit was filed on the 8th of February, 2024, while the primary itself took place on the 22nd of February, 2024. So it means that the suit was filed even before the primary. Now, the next question is, who filed the suit? Delegates. Whether delegates are competent by law to challenge the outcome of a primary.
That's another issue.
That's another issue. Now, the authorities we have, if you look at Section 84, subsection 14 of the Electoral Act, it says clearly that the outcome of a primary can only be challenged by the aspirant. Any of the aspirants can challenge it. And then if you look at the case of Osage versus Enogama, Osage versus Enogama was a case decided by the Supreme Court in the year 2022. And what that case decided is that delegates do not have local standard to challenge the outcome of a primary. That the only person who has the local standard to challenge that a primary conducted is the candidate. And that decision is consistent with the provision of Section 84, subsection 14 of the Electoral Act. So now every court has jurisdiction to expound its jurisdiction. Every court can expound it, but no court has the jurisdiction to expand its jurisdiction outside the broad letters of the law. Now, whether that judgment pronounced upon by his lordship, Echo, can stand on appeal remains to be seen, because delegates clearly instituted that action. And by law, the law stipulates that delegates they are not competent to challenge the outcome of a primary. I'm not the one saying that. I'm reading to you the clear provision of Section 84, subsection 14 of the Electoral Act 2022, which says only an aspirant in the primary election has a local standard to approach a federal high court to complain about the outcome of a primary.
Let me read that provision. Notwithstanding the provisions of this act or rules of political party, an aspirant who complains that any of the provisions of this act and the guidelines of a political party have not been complied with in the selection or nomination of a candidate of a political party for election may apply to the Federal High Court for redress.
Did you see delegates there?
So what
is there delegates there?
I'm not arguing. I'm saying this is the extant law.
Yes.
And you cited a case law as well.
The case that I've cited is Osage versus Enogama, which was decided by the Supreme Court.
So there's both a precedence and an extant law.
Yes.
What was now the reasoning of the judge?
That is why I said I will not stand here and condemn the judge without seeing the processes and looking at the justification for his reasoning, for his conclusion. Until I'm able to see the justification for his conclusion, as well as read the judgment in full, I won't be able to condemn what he has said. But looking at the broad letters of the law, it raises jurisdictional issue. The jurisdiction of the court in matters of nomination is very narrow. It's limited to a situation where an aspirant is aggrieved by the outcome of the primary, an aspirant in the election. And then Enogama also ruled that delegates have no local standard to challenge the outcome of a primary, except the facts are distinguishable. I'm inclined to believe that it's a matter that will be resolved by the Court of Appeal.
I know we've almost... I don't want to use a strong word because we have to respect the honorable justices. Let's also talk about your colleagues who also know that there is an extant law and there is a case law that precedents that showcase. How come they also pulled this off without necessarily, didn't they see this before, or why could they have taken this to the court?
You see, every case has its own peculiarities. You can distinguish a case on the index of facts.
Okay.
Or you can also distinguish a case on the index of on the basis of the circumstances. You could also look at some other factors, because when a decision is handed down, it is handed down based on the peculiar and the facts of each case. I have not seen the reasoning or the justification of His Lordship, Honorable Justice Echo. I have a lot of respect for him. I've done a number of cases before him, and I know he's a very sound judge. So he may have his justification for it. But I'm saying that this case has definitely raised issues of jurisdiction.
Okay.
It has raised some other issues of whether of local standard.
Local standard, yes, as well. Because
and then those are interesting issues that will be litigated at the appellate court.
Let us say it means that it's not Uhuru yet for those who are celebrating.
Yeah, it's not Uhuru. Either side, it can go either way. That is why you see, let me make this clarification.
All right, in rounding up.
You see, a judge sitting as a judge can't make mistakes. Because a judge sitting alone as a judge can make mistakes, there's the mechanism for an appeal to the Court of Appeal, where you have 3 justices who can look at both errors of facts, or misdirection based on errors of facts, or misdirection based on errors of law, or misdirection based on errors of misfacts and law. That you will find out. At the Court of Appeal, we have 3 justices are sitting. And after they look at it, if you are still agreeing, we can still go to the Supreme Court. We have 5 or 7 justices can look at it, depending on the nature of the case.
So clearly we're talking on the Riverside jurisdictional overreach, on the Edo side local standard.
Yes.
Dennis Silk, we must thank you for your insight as always on the program. Thank you so much.
It's my pleasure. It's my pleasure.
Senior Advocate of Nigeria, Wahab Shitu, bringing insight to the conversation. Thank you, sir.
Thank you.
Well, we'll go on a quick break. When we come back, we'll be joined by one of the parties. It's a PDP case, but it's a house that appeared to have been divided against itself. But right now, we want to talk to them about the outcome of this judgment. Stay with us.
Your guy. Now Olumide Akpata. See us we dey like beans and rice. Edo people, I will never leave your side. I will never ever. I dedicate my time forever. Time to you, my people. Even if the road be rough, I know mine. 'Cause together we shall stand.
Make we all come out on election day and vote Olumide Osaigbovo Akpata, una guy, as governor of Edo State. He ready to change our story and bring better life for we and our pikin them. Vote Labour Party, the party for Papa, Mama and pikin. Make we vote well, oh. Oludi, confirm. Now you be our guy. Labour Party, forward ever.
Olumide Akpata.
Did you know you can access electoral information with just a click? Introducing Nigeria Elections, an inclusive artificial intelligence platform that guides citizens on Nigeria's electoral and civic landscape. Say bye to misinformation and disinformation. Visit www.nigeriaelections.ng today. Nigeria Elections, addressing democratic questions.
It is new, it is unique and of international standard. Maduka University. Maduka University, a modern university of international standard with modern facilities for learning, committed to training entrepreneurs across different fields of human endeavor, offers admission to students in different courses such as law, accounting, medical lab science,
cybersecurity, mechatronics,
mass communication, nursing, pharmacy, ICT, computer engineering, civil engineering, Jube program, and a lot more. Maduka University is located in an environment of serenity, safety, and security at Ekwebe Nsukka, Enugu State. For more inquiry, visit our website, madukauniversity.edu.ng, or call 0805-509-1802 or 0915-789-3107. Maduka University, the place for the transformation you seek.
The Duchess International Hospital caters to every aspect of a family's health needs. A one-stop shop for maternity and child health services, emergency medicine and critical care, medical and surgical subspecialties, dental and eye care, and a range of other subspecialties and services, all available at a single location right here in the heart of Ikeja. And it really doesn't matter if you're paying out of pocket using your HMO or private insurance. We focus completely on providing that world-class affordable healthcare for all the family at all times.
The Honorable Minister of Works, His Excellency Senator David Umahi, CON, cordially invites the public to the stakeholders' engagement on Niger and Kwara State 313-kilometer segment of the 1,000-kilometer Sokoto-Badagry Superhighway, as well as the Nasarawa, Kogi, Benue State, and FCT 284-kilometer segment of the 477-kilometer Cross River, Southeast, North Central Apo Abuja Superhighway, scheduled as follows. Niger and Kwara State, Thursday, 4th of July, 2024. Venue, State Banquet Hall, Ilorin, Kwara State. Time is 12 noon. Nasarawa State, Kogi State, Benue State, and FCT, Friday, 5th of July, 2024. Venue, Nasarawa State Exco Chamber. Invited guests include governors of concerned state, Senate, and Federal House of Representative Committees on Works, Honorable Minister of Line Ministries, emirs, royal fathers, professionals, and technocrats, Nigerian Communication Commission, and major telecommunication service providers, Nigerian Institute of Estate Surveyors and Valuers, Nigerian Society of Engineers, and other relevant stakeholders and media. Announcer Yakubu Kofamata, Permanent Secretary.
Now, all of us like to chop better food. Food where they make body tranga and vegetables where fresh like say tomorrow not day. We want make the chocolate sweet the way we go like them. No cubes. Now be the secret. Then make them with correct ingredients like chicken, parsley, garlic, plenty iron corn full and palm to make your chocolate palm bar for you. Come the sweet well. Now be the cocoa. Make we carry salute, throw away give no.
Change your world by changing waiting day your plate.
Did you know you can access electoral information with just a click? Introducing Nigeria Elections, an inclusive artificial intelligence platform that guides citizens on Nigeria's electoral and civic landscape. Say bye to misinformation and disinformation. Visit www.nigeriaelections.ng today. Nigeria Elections, addressing democratic questions.
Welcome back. We now head to Benin City, the Edo State capital, to get the feel of the camp of the People's Democratic Party concerning this particular judgment that we just talked about with the NSF, where the primaries was nullified by Justice Anyekwo for, excluding some members who are delegates in that particular exercise on February 22nd, 2024 at the Samuel Egbemudia Stadium. We've been joined by the Deputy DG of the Aswe Godalo Campaign Organization, Mr. Don Pedro Obaseki. Mr. Obaseki, thank you so much for coming on the program.
Thank you so much, Jeffrey, for having me.
Give us a sense of what...
to be here.
Absolutely. Give us a sense of what is going on in Benin City and within the party. I'm sure we've seen this statement and the release of the PDP, but maybe you can give us an overview of how you're condensing all of this.
In fact, I want to start by saying I want to thank you, Jeffrey, and the Channels crew for bringing Wahab Shitu, Senior Advocate of Nigeria, a most learned silk, and he has just told you exactly what. Can you hear me?
Yeah, I'm in the studio.
Yes. What he just told you is very simple, that what has happened has little or no precedence in law. So what the pronouncement was, and when I hear they say it was the judgment nullified the primaries, absolutely not. That is a fallacy. So because Section 8414, he has already cited it by the Supreme Court based on the Osagie Enorama orders in 2022, had actually stated clearly that delegates have no locus to challenge the outcome of the primaries. But not stopping there, are these persons that is talking about Kevin Mohammed, Okoduwa, and Osagie, They were not even delegates because they are challenging the Congress that led to the selection of the delegates. And when you even look at it from a sheer arithmetic point of view, 378 of them purportedly. Meanwhile, in an election that was won, in a primaries election that was won by 577 votes by Aswa Ighodalo, if you even put it together based on extant and precedents of judgments by the Supreme Court of Nigeria, it is of no effect whatsoever. So when I look at it, I felt a little sad that I saw some videos of men who are supposedly intelligent men I thought prior to now, dancing. And I said, oh, what much ado about nothing. I will quote Shakespeare. Shakespeare says clearly, that is like a tale told by an idiot, full of sound and fury, and signifying nothing. Now, as a lawyer, I want to state this clearly. I, Dr. Pedro Obaseki, I am even wondering whether it's even necessary to even appeal the judgment, because it's absolutely of no consequence. What was displayed there by this, I won't even call it judgment, the pronouncement made by Justice Ian Eko. Thank God I'm not a practicing lawyer who will go to his court tomorrow. You know, borders, you know, Ogashitu was a little careful. Borders on something close to judicial rascality. Because in this same case, in law, we call it res judicata. In this same case, filed by someone who might have been a participant in the process, I'm talking about Hadiza Umoru, who had collected forms, actually, to contest. On February 19th, filed a case on the same list of delegates and filed it at the court of the Justice Ian Eko. And I want to quote him. I wrote what he said down. He said that the plaintiffs, those who had the locus to challenge these primaries, did not establish whether or not they have been affected by the decisions of the party to hold the primary stores, and he struck all them out. Now, in this case that has just happened, what he declared is very simple. I will read what he said. Do you have
the certified true copy of the case?
Oh, I don't have the certified true copy. I only have a line I read on your website.
Okay.
You get my point? And he says that he thinks that the argument of the plaintiffs met its merits. But there was no declaration, neither were there an enforceable pronouncement that I, based on XYZ, I hereby nullify, cancel.
Okay, so that we're clear, Mr. Obaseki, since I don't have access to the CTC, let me be sure I heard what you said, because before you can even appeal a case, before you can go to town with a judgment, there has to be enforceable decisions in the certified true copy. Are you saying there are no enforceable pronouncement, decisions of court from what Justice Eko did today?
I'm saying that what was read out today and pronounced in court today, while awaiting the certified true copies, look at all the lines, even on your site, on the major newspapers. He agreed that 378 persons were unlawfully denied or unlawfully excluded from taking part in the process. Now, that is different from saying that though as a result of this unlawful taking or unlawful exclusion, it has thereby invalidated the primaries. No, number two, by law, a plaintiff cannot get what he or she did not plead ab initio. Now, in the originating summons, what they pleaded was to request a right to participate in the primaries. Now, the primaries have long come and gone. So this is actually an academic exercise.
I understand, but we're totally out of time. Won't it be dangerous for you not to appeal the case? I understand perfectly what you're saying.
No, I'm not saying, no,
hold on, because I know there are prayers and there are grounds for those prayers, and there has to be a pronouncement of courts that are enforceable by the court before it can be appealed and all of that. Won't it be dangerous for you not to at least appeal the case?
No. I did not say we will not. I said if it was me, I won't. but the party will, for the record. Because even if we appeal and we win in the appellant court, it's for the record. Nothing that has happened today, neither the pronouncement of Mr. Justice Ian Eko can upturn the train has long left the station. That is true. And in fact, let me just say this as a closing remark. I want to beg, 10 seconds. I want to plead to all Edo peoples everywhere to please shine your eye. And I feel sorry for my young man who blew this out of proportion. A young man called Adaze Erata. He got out of the court, the counsel of the plaintiffs, and has fed Nigerians with multiple misleading information, disinformation.
For the records as well,
on legal rascality.
For the records as well, I need to say that we also reached out to him with phone calls and all of that, so that he could be part of the conversation, but we couldn't get his response, so that we could have a balanced conversation.
I will be very happy if you bring him on and I sit down to banter words with him.
But we're totally out of time. Don Pedro Obaseki is the Deputy DG, Asu Ighodalo Campaign Organization. We will have the conversation even further in the coming days. Thank you so much for coming.
Thank you, Jeffrey. And I like your suit.
I appreciate it. All right, so we're not done yet. One more issue. The EFCC had made a release warning promoters of planned protests, and that has gotten some flags for them, against them rather, and it's been a conversation for a long time. That's why I want to talk about this within the short time we have about the EFCC warning against a planned protest. They said that this protest has been instigated against the commission, and they're even alluding to the fact that certain elements maybe that are under prosecution and all of that are behind all of this. So that's what we want to talk about in the few minutes we have with Mr. Chido Onuma, who is a social activist. Mr. Onuma, thank you so much for coming on the program. He joins us from our Abuja studio. Thank you, sir.
Thank you for having me.
So let's begin with your quick overview, because we need to, Shakespeare said, brevity is the soul of wit, so we need to be snappy with this. When we saw the release by EFCC warning, these are things we usually see with the DSS. The EFCC, Economic and Financial Crimes Commission, so people were wondering whether we're warning against the protests. Maybe you can help us make sense.
Well, I haven't seen, or I didn't see the release. Perhaps if you could explain maybe in a few words exactly what
well, maybe I'll just read the first two paragraphs. The Economic and Financial Crimes Commission wishes to alert the general public on a plan by a shadowy group to instigate a protest against the commission. In the last couple of days, the group has been actively campaigning in the social media, recruiting impressionable young Nigerians, including students, to take up arms against the EFCC. Now, this is on the background of the fact that we've seen even recently where the EFCC chairman had to give an order for some of his people to be brought to question because they went for an assignment or a mission and a lady was assaulted. So people are complaining about their quote-unquote Gestapo approach in doing their job. So perhaps the young people are fed up and tired and they are saying this can no longer happen again. But the EFCC is saying it's not just about that. There are undertones to this.
Okay, so I think it makes absolute sense. People have the right to protest. As Nigerians, we can protest bad governance, we can protest corruption, we can protest the poverty in the land and so on. It's within our constitutional rights, and I think the law provides cover for people who want to embark on protest. Just the same way that the EFCC also has the right to explain itself, explain its position. If it has intel, for example, those behind this planned protest, what the aims are. It's important that the EFCC issues a statement giving its own side of the story, so to say, to alert the public. I'm not sure from what you read that the EFCC was calling for consequences for any protest. I think people should just look exactly at the tone of the message in sense that this is happening and the commission feels obligated to inform the public that we know that this is being organized by certain groups, certain individuals, either because they have been at the receiving end of some of the actions that the EFCC has taken. Clearly, if people have grievances, whether with the EFCC or any agency or institution of government, there are also, I think, opportunities and channels to address these grievances. And I read the part, or I saw the press release where the EFCC cautioned its staff and also said it was going to investigate. And I think the EFCC has made efforts recently to address some of these concerns by the public.
Okay, but in looking at generally, because they say they are not averse to protest, but they are just calling for caution, given the fact that they are suspecting a few things that may be a threat to national peace and security. But looking at the reputation of the EFCC and their style recently, are you concerned? Because given what we've seen with the incident that called for reprimand by the chairman, they say first time could be an accident, second is a coincidence, third is now deliberate. Are you worried about some of their style as a social activist?
I'm not. I mean, every institution, agency has its bad eggs. The important thing is the kind of response you get from the leadership of the organization. And once this happened and it was in the public, the leadership took action immediately. I don't see how the EFCC can, and I don't think it's within their powers to stop people from protesting. Yes, they can caution or explain to the public that this is what we know, these are the people responsible for this, and it's left for Nigerians to take a decision on that. So I don't think the actions of one or two individuals within the commission or one or two operatives of the commission can be said to be representative of how the EFCC operates its modus
without trying
operandi.
Mr. Onoma, without trying to speak against the EFCC, if you follow, that's why I use the word accident, coincidence, and deliberate. And what it's doing to the reputation. It's an institution of government and our institution as Nigerians, so we must protect it. But so who checks some of the excesses of the commission for those people who are going against the law and spoiling the work of the good elements within the commission?
Yeah, of course, the EFCC, like other organizations in the country, has internal mechanism to check the excesses of staff. But again, I keep alluding to the action that took place immediately. We saw the viral video of the assault during a sting operation. So the point is that is action taken when this thing comes to the attention of the leadership of the commission, or how much do we know of the internal mechanism put in place to check the excesses of, just like the police or the military or other law enforcement agencies? You have criminal elements within these organizations. You have bad eggs, as we say in Nigeria, within this organization. The important thing is the response. And I think in this situation, the commission has responded swiftly to the concern. So the issue of protest, it's really different. People have the right to protest and they can express their grievances. And the EFCC also has the responsibility to alert the public about what it feels that this is all about. And it's left for Nigerians to judge at the end of the day based on what those who come out to protest do and also the kind of action and responses that the EFC puts up in when it... I think that one other important point to make here is the question of communication. We're totally out of time. The EFCC needs to do more education and communication with the public to reassure them of its duty and responsibility. And I hope with that, this tension that in carrying out its activities, people will not read negative elements into it.
Mr. Onoma, I must thank you for your perspective. You know, the reason for some of these things is that the public perception is that there's a lot going on when it comes to chasing Yahoo boys and getting results and chasing corrupt political figures who have looted billions and billions of naira. So maybe the public wants that same energy used to chase people that are fraudulent on the internet, to also chase people that are their hands in the cookie jar, perhaps. But I must thank you. Mr. Chido Onoma is a social activist. Thank you so much for coming on the program.
Thank you.
All right, that's it on the program. Thank you so much for your time and, of course, your company. We'll continue to watch the polity. And as far as we're concerned, we'll bring it to the fore to make sense of that situation every day of the week right here on Politics Today. Thank you for watching. I'm Jeffrey Uzama. God bless the Federal Republic of Nigeria.
Wow, look at that. Until recently, I had no idea what a pangolin was. Man, this thing is strong. It's a small mammal covered with scales made of keratin, just like our nails. Strong scales, man. The scales has no medicinal value, yet the demand for the scales and the meat is driving the pangolins to extinction. This one's name is Igai, and he was rescued from illegal bushmeat trade. He's going back into the wild where he belongs.